focus of tonight's presentation will be, as I said before, the U.S. immigration law as it relates to employment of non-U.S. citizens in the United States. The panelists will outline the different ways to get a visa and also the requirements for obtaining a green card. I would like to recognize our speakers and the law firms that they work for, as without their support the panel would not be taking place. From left to right, William Johnson, Associate at Kramer, Levin, Naftalis and Frankel, Sarah Dahl, Partner at Kavanagh, Dahl and Knight, and Zach Hatzis-Maxlovic, Special Counsel at MacArthur and Inglis. And I would like to ask you now to introduce yourselves so the audience can get to know you.
So I'm Willie Johnson. I work at Kramer, Levin, Naftalis and Frankel, and the firm is a full-service international law firm. We have an office in New York, Paris, and Silicon Valley. I work within the business immigration group at the firm, and we're 15 members, and we manage employment-based matters for immigration matters for companies, Fortune 500 companies to small startup companies. I myself have a focus on the Spanish financial industry, and I'm fluent in Spanish.
Testing? Yeah. My name is Sarah Dahl. I'm a partner at the law firm Kavanagh, Dahl & Knight. I've been with my partners for 2 years, but we formed our law firm last year. We're a boutique law firm, and we specialize in corporate law and immigration law. We help companies get set up in the U.S., and we represent them in the U.S., and then we help them with their immigration needs and their corporate law needs. We're very active in the Spanish chamber. My partner, Hayes Kavanagh, has been the chamber secretary for a number of years. Hayes and I wrote a visa book about visa options that was published with the chamber. The last edition was 2007. And I've been doing immigration law since 2006. I'm originally from Wisconsin, and I went to the University of Wisconsin, and I spent my junior year of college in Madrid. And I'm also into running, and I've run the New York City Marathon 9 times.
Cool. Hala Madrid. No? All right. I really didn't expect that you guys would be here. I thought somebody would be out there celebrating. Not bad. Champions League. Anyway, long story. I'm an attorney. I work for a firm called MacArthur and English. They're about 170 years old. They're one of the oldest firms in the United States. I do immigration law, all aspects, and I also do defense, trade, advisory, export controls.
Great, thank you. Even if you are not familiar with the U.S. immigration system, you probably know that each type of non-immigrant visa is designed by a letter and sometimes a number. At the same time, all the non-immigrant visas are organized in 4 different categories. Visitor visas, like the B1 and B2, employment-based visas for business people, like the popular H1B, H2B, L1, E1, and E2. Then we have another category, visas for specialized occupations, like the O1, P1, I, and R. And then another category for trainees, exchange visitors, and students. And the final category for non-immigrant visas, like, for example, the A for diplomats. Our speakers will review during the workshop the most popular visas for business people, and then at the end of the seminar we'll open it up for questions. Let's begin with Sarah and review briefly the visitor visas, especially the B1, that is for temporary visitors for business. Sarah, who would be eligible for this visa, and what would be the direction, and most important, what are the limitations for the B1?
Yes, the B1 visa is for temporary business visitors, and the key is that this is not a work visa. This is a visa for coming to the United States for a business purpose, but not for the purpose of engaging in employment. The requirements for this category are that you have a residence in your home country that you don't intend to abandon, and that you're coming to the United States for a specific period of time, and that you're engaging in activities for that business purpose. So this would be a visa that might be a good match if you're consulting with colleagues, attending a conference, doing specific research, but it's not a visa to come to the U.S. to work.
So you can request it for as many times as you need it?
So there's two elements to the B1 visa that I would want to mention. One is that you can enter the United States under the visa waiver program as a B1 visa holder or B1 status. And what that means is if you're from countries such as Spain, you're allowed to enter without getting a visa in your passport, and you can stay for up to 90 days and engage in the activities that I mentioned. There's also something called a B1 visa stamp, and what that is when you go to the consulate and you get the stamp in your passport, and with that you're allowed to enter the U.S. Your admission is generally 6 months, and the purpose of what you can do here is the same. It's just you can stay for a longer period, and then you can obtain extensions once you're here.
Okay, thank you. William, what are the L1A and L1B visas?
Sure. So the L1 visa category is for intra-company transferees, and that visa category is for individuals who have been employed abroad for one of the previous 3 years with an affiliate, subsidiary, branch office, or parent company of a U.S. company. There are two kinds of L visas, the L1A and the L1B. The L1A is for executive or managerial employees, and managerial is defined as someone who is either supervising 2 tiers of employees, 1 tier of professional employees, or an essential function of the company. The L1B is for specialized knowledge employees, and that visa category is for individuals who have specialized knowledge of the company's products, procedures, or operating procedures. And the specialized knowledge doesn't need to be proprietary, but it does have to be greater or different than knowledge you would normally find in the workplace. The limitations on the L visa category are that someone can remain in the U.S. in L1A status for up to 7 years, and someone can remain in L1B status for 5 years. The spouses of L1 visa holders receive L2 visas, and they're eligible to apply for employment authorization, so that's often an important consideration for people coming to the United States to work.
And how long can it take for this type of visa application to be
Right,
processed
so
and approved?
the process is a 2-step process. The company first has to file an application with the Immigration Service in the United States. The agency is called the U.S. Citizenship and Immigration Service. That application can take 2 weeks to be processed. Once the Immigration Service in the United States has approved the petition, the individual then can take the approval to the embassy and apply for the actual visa. And the second step of the process can take another 2 to 3 weeks depending on availability in the embassy.
Are they usually approved? Is this
When we do them, yeah. Oh,
Okay.
no, but yeah, I mean, we'll get into a little bit later. There are some strategies for increasing the likelihood of approval through something called a blanket petition. I think we're going to talk about that later.
Yeah, in fact, I was going to ask you
But
about
right
that.
now, I would say that as a practical matter, if you're going to apply for an L1A visa through the Immigration Service in the United States, you need to be managing people, even though the regulations support the essential function category. And an L1B specialized knowledge visa is very, very difficult to obtain now, unless you have some sort of proprietary knowledge, even though it isn't explicitly required by the regulations. You're going to have a very tough time getting a case approved.
And speaking of the blanket petition, which companies can benefit from that? And
Right,
what is exactly a blanket petition?
So one of the requirements for the L1 visa category is that the sponsoring company has to show the qualifying corporate relationship. In other words, that Company A in the United States and Company B in Spain are ultimately owned by the same company, or that they're affiliated somehow. And the blanket petition is a way for the U.S. company to get pre-approval from the Immigration Service in the United States of the qualifying relationship among all the different entities in the U.S. and abroad. And it's normally larger corporations that obtain a blanket L petition. And the requirements for that are that the company has to be doing business in the U.S. for at least a year. There must be 3 or more domestic or foreign companies in the corporate group, and they have to satisfy one of the following, which is at least 10 L approvals in the last year, combined U.S. income of $25 million, or a U.S. workforce in excess of 1,000 individuals. And the advantage of obtaining the blanket L approval is that L visa applicants who want to come to the U.S. to work for that company can skip step 1 of the process. They don't have to apply through the Immigration Service in the United States, and they can apply directly at the embassy. And at the embassy, in theory, the only issue is whether the individual is going to be a manager or has specialized knowledge. And as a practical matter, the embassy is usually much easier going with the adjudication process. So it's much easier to get tough cases approved at the embassy than it is through the Immigration Service in the U.S.
So you said that the duration of this visa can be up to 7 years, correct?
Right.
And after that, just we go to the green card? Or there
For
is
the
some other-
L1A, the manager visa, you can remain up to 7 years in the United States. You initially get an approval for 3 years, and you can file for two-year extensions for a total of 7 years. The L1B is up to 5 years, and that's initially granted as well for 3 years, followed by a 2-year extension.
Zach, many companies from Spain investing in the United States are now applying for E1 and E2 visas. Let's begin with the E1 visa. When would you recommend a client to apply for an E1 visa?
I'm sorry. It's a good solution for folks who would not normally go the new Office L route, I guess. It's a good solution for companies that intend to bring in more than just one person, maybe teams of people. These are visas that basically exist as a result of treaties that the United States has established with countries throughout the world. So with Spain, I think the treaty was established in 1903. And what you have is either the E1, which is substantial trade, or the E2, which is substantial investment. So you have to prove to the Department of or Bureau of Consular Affairs, meaning the consulate, wherever it is that you're applying in your home country, that you are about to invest a substantial amount in the United States if it's an E2, or you're about to do a substantial amount of trade with the United States, or from the United States with your home country. They are document laden. They are petitions that require you to put together a very good and detailed business plan, and they are valid for as long as the enterprise is functioning at that level. Now, what does that mean? The folks who are reviewing these things are looking to see that this is not just what I call a Playboy visa, right? So they're not going to grant something that's going to generate enough money for the principal visa holder to be here in the United States and support himself. They're looking for someone who's really investing here, hoping to employ folks. It's going to be a proper enterprise. And the way to establish that is really, initially, you're showing contracts, lease for premises agreements, money at risk, so not just parked in a bank account. So for a lot of folks, unless they can substantiate all of that, it's difficult to do, because all of this has to happen, meaning establishing the company, the bank accounts, and all of that, before you're actually granted the status. A positive thing is that it allows the dependents to work. A negative thing is that it's generally not considered a dual intent visa. What does that mean? It's not an easy step to go from an E to permanent residence. It's not impossible, but at the same time, it's more difficult than from an L, for instance, or from an H-1B. So that's kind of the general overview. By the way, I should do this. You know, whenever I speak at these things, my guys at the firm tell me, always make sure to tell them that, you know, this is not legal advice. They should not rely on it. It's just general stuff.
So how long would it take if you have everything as you should have? How long does it take for this visa to be processed?
It depends on the consulate. You'll have consulates that are able to review the documentation in a couple of weeks. You'll have consulates that'll work on it for about 5 weeks, 6 weeks. You put it together, you send it. They typically then interview the applicant, because what you're doing is you're registering the treaty company, and then they're interviewing the principal, whoever it is that's applying for the first visa.
So the process is very similar in the case of E1 and E2, right? It works similarly?
With regard to the application process at the consulate, yes. With regard to what you're trying to substantiate, it's different. You're showing that, with regard to an E1, you're showing that your trade is going to be principally between the United States and the treaty country. You're only eligible for the E1 or E2 if you are national of the country with which the United States has a treaty. So at least 50% of the company's ownership has to be from that treaty country. It doesn't have to be one investor, it can be a group of them, but their share of the company has to be at least 50% in order for it to qualify.
Okay, thank you. Sarah, one popular visa is the H-1B. When would you recommend a client to apply for an H-1B visa? What's the maximum duration? I know there are a number of visas allocated, so how many are available per year, and when should they be requested, if there are any specific deadlines for that?
Okay, well that's an easy one, because the magic date is April 1.
April 1.
Yes, so there are 65,000 H-1B numbers available per year, and an additional 20,000 for U.S. master's degree H-1B numbers. And so those become available each fiscal year on October 1. You're allowed to ask for them up to 6 months before that date, which is April 1.
Great.
So what that means is everyone in the current climate gets all of their paperwork together, and everybody files their H-1B petitions on April 1. And what's happened the last few years is there's many more petitions filed than numbers available. For example, in this past year, they received 172,500 H-1B petitions during that initial period. So what happens when there's more petitions received than numbers available, they end up doing a random selection process or a lottery, where they literally take the cases that they received and they sort them and pick the ones for adjudication.
Okay.
So
it depends on the country, or
no, it's literally a random selection process, a lottery. So the key takeaway from this is April 1 is the magic date that you have to get your paperwork on file, so you need to prepare ahead of then in January or February, start investigating your case, your strategy, what you're going to do, so that when the day comes that you're ready to get your case there during when the filing period opens. Because if you decide to file it 3 weeks later, it's going to be too late. You're going to have to wait the next year until April 1, essentially.
So then the date is April 1, and then you have to wait until October to have
Correct.
the visa.
Correct. That's the start date on the.
Okay.
That'll be the start date on the H-1B visa.
Okay. So during that time, you cannot be here working, right?
Well, now that's a sort of case-specific situation. If you're here on a student visa and you have a
Okay,
work
you're a
card,
client.
yes, there's certain provisions that will allow you to stay here and keep working during that time.
Okay.
So you have to look at your exact facts, but you might be fine to stay here.
Okay, and it could happen with a J1 visa as
Right.
well.
So the J1 visa, they don't have this special provision that allows them to stay here and keep working. So they'll have to abide by their J1 and then perhaps take a trip home to wait for their H1B, you know, assuming they're hopefully picked.
And what are the possible main reasons for H1B denial?
Well, the category requires that you're doing a professional job in a position that requires at least a bachelor's degree in a specialized field of study. So the key is you have to meet that, and if you meet that, then there's a good chance that your case should be fine. The issue is more that people put together perfectly wonderful cases, but they don't get picked for the lottery, and then they're out.
Thank you, William. Even if it's not exclusively for business people, could you possibly describe the O1 visa and who's eligible for that?
Sure. So the O1 visa category is for individuals of extraordinary ability. The standard for showing extraordinary ability depends on the field in which the applicant works. For individuals working in the arts, they have to show distinction, which is defined as skills and recognition substantially above others in the field. For those working in the television or film industry, you need to show skills and recognition significantly above others in the field. And for the sciences, education, business, and athletics, you need to show that you're one of the small percentage who have risen to the very top of the field. So, and it's important which way you couch the case, because the different standards matter. And for example, the standard in the arts is much easier to satisfy than the one in the business. So if the attorney or the employer can categorize your position in a way to get you in the arts category, you're in a much better position to get approved. Now the O1 visa is most frequently used in the arts and entertainment fields, but it's also a good fit for people who have been in the United States in another non-immigrant category. So let's say H1B or L1, and they're now running out of H or L time, because the O1, there are no limits in theory on how long you can hold it. So once someone's H1B time runs out, one strategy is to then get them an O1 visa to enable them to remain in the United States for a bit more time. It's also a good strategy if you were unlucky and you didn't get selected in the H1B lottery. If you have some experience and you can document recognition in the field, you may be able to qualify for an O1 visa.
Let's talk now about the green card. We know that there are several ways to qualify for a green card. I guess the most straightforward would be to have a close relationship with a U.S. citizen. I'm not saying that you should do that, but that's one of the ways. Or playing the lottery, that's the other one. Another way to qualify for a green card is an offer of permanent employment in the United States. Zach, can you talk to us about this one?
So, employment-based permanent residence is really all about numbers. There's a statutory limitation on the number of immigrant visas issued every year. Let's put the number at 150,000. Then there's a per country limit, and let's say that that's 7% at the top, right? These numbers are doled out in what are called preference categories. You have priority workers, that's the first preference. Those are generally folks who are multinational managers, executives, aliens of extraordinary ability, outstanding researchers or professors. The U.S. government has deemed these folks to not require a test of the labor market, the domestic labor market, because they are special. We need them. That category is generally available, it's current. So if you apply for an immigrant visa, you are generally able to concurrently apply for permanent residence in this category. Why is that important? Well, the processing time for that is much shorter, right? The next two categories that you are most often going to be seeing are the second preference category, meaning folks who have offers of employment that require advanced degrees or a bachelor's degree plus at least 5 years of progressive responsibility in a job that's posted out there. That category will require the petitioning employer to do a labor market test. So it then becomes really a tripartite process, right? So you have the labor certification, which is a prerequisite to move on to the next phase, the immigrant petition. And then if the category is available for your particular country, then and only then are you able to apply for the last phase, which is the application for permanent residence. Folks can be in a category that's oversubscribed, right? And they have to wait. So an application for permanent residence could take years. During that entire time, the burden is on them and their employer to keep extending the underlying work authorization, whether it's H-1B, L status, whatever it is. They still need permission to remain in the United States because the mere fact that you've been approved for a labor certification or an immigrant petition provides you absolutely no status in the United States. You still have to have a valid underlying non-immigrant status, right? That's the second preference, advanced degrees, right, or higher. Third preference is where the largest chunk of folks fall in, which is bachelor's degree. And if you happen to be from a country like India or China, and you happen to be applying for a green card, you will be waiting for sometimes a decade just to get to that last phase. Spain hasn't been oversubscribed in many years, as far as I know. So assuming that you have an offer of permanent employment from your employer, I would venture to say that the whole process, start to finish, could be about a year and a half, based on current processing times.
And the way the program works is that if you invest $1 million in a new commercial enterprise and you can show that that $1 million investment creates 10 jobs within roughly 2 years, you can get your green card. So you're essentially purchasing the green card. The advantage to the U.S. government, obviously, is that you've now created 10 new jobs. That amount, the $1 million figure, can be reduced to $500,000 if you invest in what's called a targeted employment area, and that is defined as either a rural area or an area of high unemployment when compared to the national average. In addition to showing that the investment creates 10 jobs, you need to play an active role in the organization, either managing the business, or you have to be involved in the policy formation. When the program was initially created, it didn't gain very much traction. So what the government did was to create another program with these entities called regional centers, which are pre-approved economic entities designated by the government as participants in the EB-5 program. And what these regional centers do is they pool investments from a number of investors. So it could be anywhere from 10 to 100 investors. And the advantage of investing through one of these regional centers is that in addition to directly created jobs, so employment that people are going to be working for the regional center's project itself, the regional centers get to count indirect jobs. So they get to count jobs that are going to be created at the restaurant next door because there's going to be more people living in the town because of the project. And it also makes the management requirement a little bit easier because through the regional center you can become a limited partner, and that usually satisfies the management aspect of the case. So the advantages are indirect jobs and you don't have to be involved with the day-to-day operations of the business.
So do you think that this way to qualify for a green card makes the process faster, or it's going to take a year and a half as well?
I mean, it's probably, given current processing times, it's going to take longer than that. I mean, I'm guessing it would take anywhere from 18 months, roughly 18 months. And the way it works is you initially are granted conditional permanent residence, and in 2 years you have to file another application showing that the jobs that you said you were going to create were actually created. And at that point they give you the green card without conditions, and you're a permanent resident just like anybody else. So the entire process from start to finish can take several years.
Several years. Okay, but the conditional, the one you get at
The conditional one you can get, yes, I would say between 12 and 18 months.
Okay.
So it used to be a lot faster, but now it's slowed down quite a bit.
Okay. So regarding the green card for an exceptional ability in business, I guess it works a little bit like the visa, right? The
Yeah.
O1.
Yes, it sounds very similar to the visa, but it's kind of looked at a little more strictly since you're going for a green card. The standard is that you have a level of expertise indicating that you're one of that small percentage that's risen to the very top of your field of endeavor. So that's very specific. It's you're not distinct. You're not, you have to be one of the very best at what you do. And this type of case is typically filed with a lot of evidence, and what you're trying to show is that you have sustained national and international acclaim, and that your achievements have been recognized in the field of expertise. So this category obviously doesn't apply to everyone, but if this is your situation, it's a great category because you can actually petition for yourself. You don't have to have an employer sponsor you. So it can be really great.
And again, I guess like in the O1 visa, I guess it's easier for artists to justify.
No, this is just this standard applies to everyone.
To everyone.
Yes. So the O1 has the different levels, but this, when you're going for the green card for extraordinary ability, it's the single.
Okay.
I would call it the higher standard.
Okay. So I'm sure we have many people here in the audience that is interested in the lottery. So how does it work?
Well, so the lottery is really, in fact, a lottery. What it is you, the State Department, what the category is it's 55,000 green cards per year that they give out in a lottery, essentially. And the way that they do it is they select all the people that apply who meet certain eligibility requirements, and it's from countries with low rates of immigration to the United States. So certain countries can apply, but many, many countries can, including Spain. And the way that you apply is you go to the Department of State's website, and there's a specific registration period, and you go and you do an online application, and you submit your information, and then they do a computer drawing, and they choose the people who are selected for the lottery, and then you essentially have a year to complete your
Application.
complete your process. Your process has to be completed to a successful conclusion within that period of time, otherwise you lose the benefit. So this is the type of thing that if it happens to you, it's great, but it's not really something you can plan on as like a strategy.
Like a plan B, right?
Right.
Okay. So finally, William, could you please introduce a little bit the J1 visa? I mean, the Chamber is a sponsoring organization of J1 visas, and for those who qualify, the process is very straightforward, and in fact, it can take as little as 1 month, I would say.
Right.
We in fact work a lot with Kramer and Levin in J1 visas, so if you can tell us a little bit more about this type of visas.
So the J1 exchange visitor status is administered by the Department of State, and there are several different J1 categories. There are J1 categories for students, for scholars, for camp counselors. But I think the two J1 categories that are most pertinent to this discussion tonight are the J1 trainee and the J1 intern categories. And unlike other visa categories where you first have to apply either through the immigration service in the U.S. or directly at the embassy, you have to, for a J1, you apply through a pre-approved J1 sponsoring organization, and the Spain-U.S. Chamber of Commerce happens to be one. So if you ever need help in that regard, they can certainly help you. Yeah. Now the J1 trainee category, well, let me take a step back. The J1 trainee and intern categories are for training. They're not substitutes for work visas, but there can be sort of an on-the-job training component. But the primary purpose of the assignment really should be training. It's not supposed to be a substitute for an H-1B or an L visa or another work visa. To qualify as a trainee, you need a post-secondary degree in 1 year of experience abroad, or 5 years of work experience in the field of training. J1 trainees can stay in the U.S. up to 18 months, and spouses are eligible to apply for employment authorization as well, as long as they can show that the money they make from their employment won't be used to support the principal J1. J1 interns are individuals who are currently enrolled in school, or individuals who have graduated from a foreign post-secondary institution within 12 months of the start date of the J1 program. And a J1 internship can last up to 12 months. One thing you want to be careful of with the J1 visa is something called a 2-year home residency requirement. And the 2-year home residency requirement applies to certain Js, and it requires them to return to their home country after the J1 program for 2 years before they can obtain HL or permanent resident status. You can trigger the 2-year home residency requirement in 2 ways. The first is if there's any government funding of your training program. And the other is if your area of expertise is in demand in your home country. And the Department of State maintains a list of professions that are in short supply in each country. There are waivers to the 2-year home residency requirement. They can be difficult to obtain depending on why it applies to you. That's it.
Okay, thank you, William. Let's open it up now for questions. If there are any questions. Can we take them? Hold on just 1 second. If you can just stand up and introduce yourself.
Hi, my name is Ignacio. I'm here in the US. I was in a J1 visa for a year, and I've been moved by my company to an L1B currently. And my question is basically, if you're in an L1B visa, are you allowed to start any business in the US on the side while you're working at the same time? Or do you actually need to take some kind of condition like American associates, or you cannot do it?
Let's start with Zach. Would you like to take that one?
Well, you can start a business. Are you going to be doing any productive work for that business?
Well, I mean, like,
That's it, yeah.
there's the main
I'm just
reason.
kidding, Ignacio.
Yeah, you can have it on the side, you know that.
No. You, as the sole proprietor of that, if you're doing productive work in the United States, your visa allows you to work for the sponsoring employer of your L1B. Period. That's it. Full stop. In order for you to do something else, you can start your own company, get a new office L, for instance. Well, not a new office L because you wouldn't be eligible. You would have to be working abroad for that company, but you could try with an E, for instance. There are some indications that the USCIS is now approving H-1Bs for sole proprietors. I've never gone down that path, and what I'm hearing isn't all that positive. I don't know if that answers your question.
Pretty much. I know there's been some problems with the L1. I know there's been, when I was being moved, I know there's been some problem with applying to an H1, in my case. And I just wanted to know if like that basically that limitation. So you basically answer yeah.
Any more questions? Yes.
Okay, I can speak loudly.
Yes, you can.
Converting from a J1 to one of the other visa types, I was under the impression that you had to go home at the end of the J1 training period. Is it possible to apply for a different visa while you're on a J1 to convert to, say, H1B or something similar? Or do you have to go back to your home country and then reapply after the mandatory period?
Sarah, do you want to take that one?
Sure. Well, when you're filling out when you're filling out all your J1 paperwork, part of it says somewhere, I realize that this is a temporary work visa and I'm going back to my country when it's over. So the cleanest, best situation is you should go back to your country, and whatever future work visa you want to have, do it separately, not try and do it as a transition from the J1 to it. Might it be possible in some circumstance? It might be possible, but I think that it could be problematic, and I wouldn't recommend it in most cases.
Okay.
Hello, I'm in just this same situation right now. I'm in a J1 visa and a traineeship. And I think that the company, well, I'm sure the company wants me to stay after the J1 visa expires. So from the point of view of the company, what is the best thing a company can do just to keep me there with them after the J1 visa period expires, so I don't have to go back to Spain and then come back?
William?
Kind of the same question then asked a different way, I guess.
Right. So, I mean, it would first depend. Obviously, the company's going to want to initially look to see if you qualify for another temporary work visa, and depending on the answer to that question, they would make a determination as to whether or not you would have to go back to Spain to apply for the visa, or presumably Spain, or if you could somehow change your status while in the United States. And also, certain J1 programs make you sign statements saying, or not the foreign national, but the company, promising that they won't, file an H-1B for you, that they won't seek to employ you beyond the completion of the J1 program. So it's really, we would need to, find out more about you and about the company to determine if there are other visa options available for you. And if the answer is yes, depending on those options, we could determine whether or not you had to go back to Spain or you could do it while in the U.S.
Any more questions? Here.
Hi, I have two questions actually. I don't know if I can ask two questions, but I have two. One's for me. I've been working for the Department of Education since 2007. Applied for my green card in 2009, and I have a priority day already, and the I-40 has been approved. The priority day is February 2013. So I was wondering when will I be ready to file my green card?
Zach, you want to take that one?
Your priority date is 2013?
My priority day is February 3rd, 2013.
All right, so remember how I was talking about our general counsel advising us not to give anybody advice? This whole has to be. So the bottom line is, typically if you look at your priority date and the visa reciprocity tables, or the visa bulletin, I'm sorry. So take a look, and in your category, let's say the third preference, second preference, I'm not sure where you're in. If that category is current, you ought to be able to apply now. If the category is not current, all you're looking for is that the date that they're working on right now is past your priority date, and you're eligible to apply for the last
Yeah,
step.
I think they are filling visas for 2011 now.
You've got a ways to go.
So.
Assuming that they're going month to month, and I don't know that they are,
Okay.
but assuming that they are, it'll be a couple of years.
Okay, so it's different for
Yeah, it's weird things happen. You know, sometimes they'll leapfrog over 8 months.
Mm-hmm.
And
Okay.
sometimes it'll be static for 5 months.
Okay, all right. And I have another question. It's on behalf of a friend of mine, but he found a job and they were willing to sponsor him and apply for the H-1B visa, but now it's too late because, as you said, the deadline was April 1st. So is there any option that he can try to do like a Q visa? I've heard about the Q visa, but I'm not sure if it's possible to get it or not.
I don't know. I mean, it's an alphabet soup of options. It depends what he brings to the table,
Mm-hmm.
what the employer, where they can use him, you know, what kind of organization they are. Are they a media representative? You know, that's something that could happen. So it's really something that you would evaluate case by case.
Mm-hmm. Okay. Okay, thank you.
Hi, my name is Cristina Merino, and I wanted to ask about this thing that you mentioned that you can apply to a green card if you have, a company has kind of offer you a permanent job. And I didn't understand the process itself because you said it's like it can take between 1 year and 1 year and a half, but is there any requirements apart from getting the job offer?
Yes, there are requirements. So I'm not sure if I explained it properly, probably didn't, but there are 3 big categories in which you would fall. These categories are only important so as to determine your place in line for permanent residence. And let's say that if we're talking about just trying to get through the green card process fastest way possible, all other things being equal, you have an offer of employment by a company. Now, the way that you would qualify for the first preference category is if, for instance, you are a multinational manager or executive. That's one. And that really presupposes that you've been working for that same company, its affiliate, subsidiary, parent, abroad for at least 1 year in a managerial or executive role. You come to the States, where they want you to be in the States, in a similar role. You're a priority worker. That process, typically from start to finish nowadays, what I'm seeing with my clients is about 6 to 8 months. Aliens of extraordinary ability, and these can be self-petitions. You don't even need an employer. All you have to demonstrate is that you are someone who has international renown, you are in the very top of your particular field. Why is that important? Because the way that you define your field of expertise, to me, is really the most important part. If you say I'm, an extraordinary engineer, it's very likely that you're not. The reason why is that the competition is just too great. There's so many engineers, right? But if you're talking about a very specific area where you can demonstrate that you've been published, that you've been speaking on a panel like this, that your work has been reviewed by peer organizations, that you are getting high remuneration for the work that you're doing, that you've been employed in organizations of great renown, right? Those are the things that would demonstrate that you are an alien of extraordinary ability. You would then, again, I would say about 6 to 8 months now to get to permanent residence. The last is outstanding researchers and professors. Unless you're working in that field, it's really not something that we need to talk about. The other 2 employment-based preference categories, there are more than 2, but these are typically, these 3 that I'm talking about are the ones that most of the folks in this room are likely to fall into. If you have an offer of employment, it's probably going to be one that requires at least a bachelor's degree, right? Sometimes it'll be more than that. It'll be a position that requires an advanced degree, a PhD, right? Now, this is where we start talking about timelines. You have to have your employer go through the labor market test, something called a labor certification, that requires them to essentially do recruitment for your role. They're not required to hire anyone, but they need to demonstrate to the Department of Labor that there are no willing, able, and qualified U.S. workers to fill that role. And only after they've been able to demonstrate that can you move on to the immigrant visa portion, the immigrant petition, right? That is why, because it's a three-part process now, that is why it tends to take longer. Sometimes, you get things like audits from the Department of Labor. They're requesting information. It takes them a very long time to then adjudicate those audits. So you will have a process that could normally take, a year or even less, move to 2 years or more.
Okay. More questions up here?
Hi, my name is Juan Carron. I would like to ask you one interesting question. Most of the time, you don't know exactly if it's the right time. So, is there any, let's say, penalty if you apply and your case is not that good and you get a negative record? If you want to apply again for the same type of visa or another one, or there is not real a record where you apply and you get rejected for that application? Thank you.
Sarah, do you want to answer that?
Sure. I would say there isn't a real penalty. If you're talking about a work visa petition going to the Immigration Service, you'll have to disclose that you filed before. So they do have access to your record. They could look it up if they want to. But simply having a case denied once, I don't think that it's a penalty or it would necessarily prejudice you from getting a second case approved. They should look at the second case on its merits, and hopefully the second one would get approved.
I would just add that certain non-immigrant visa categories you can apply for directly at the embassy. A denial at the embassy doesn't prejudice a future application in that visa category, but it may make you ineligible in the future for coming in on ESTA, the visa waiver program. But that's only applications directly at the embassy.
So I have a friend who is in the States with an A2 visa, and he started a business with another two associates that are U.S. citizens. Now this company, they wish through this company to sponsor his H-1B visa so he can be a full-time employee of the company that he has funded. How is that possible? How would that be in conflict with once he would leave his position as a diplomat? How would or that gives him the A2 diplomatic visa? How would that work, and how would the company have to process that H-1B visa? Because I'm assuming he only has 1/3 of the company, so he doesn't have a stake that gives him power to decide on what happens on the company. So I don't see the conflict of interests.
William?
Yeah, I mean, the major hurdle now is that there are no more H-1B visas available. So if they were to file next April for an effective date of next October, like Zach said earlier, in theory they're making it easier for those who have an ownership interest to sponsor themselves for a H-1B visa. But I think as a practical matter, it's still untold how they're actually going to handle those cases.
Give me the hypothetical again. I'm not sure I understood you.
My friend is in the States working with an A2 diplomatic visa.
Okay.
He has
There are big things that he needs to account for first, from moving from that visa to something else. That's something that he needs to look into. it's not as easy as most people think, especially if it's something that he, plans on going to permanent residence with, right? But go on. So he has a business interest, a third of a business in the United States in A2 status, or A, is that?
With an A2 status.
Okay.
Yes. And he has 1/3 of the shares, and it is a working business. One of the 3 partners is already working full time. So the obviously what they would look for is all 3 of them working full time on this endeavor. However, he has an A2 visa. The other 2 are American U.S. citizens, born and raised. So the problem here is, what my doubts are, from April 1, when the company tries to sponsor his H-1B visa, until whenever it is elected, would he have to renounce to his position, the work that is giving him that A2 visa, or how would he? What are the implications? Can the company do that?
You have a viable business, and by that I mean, they can actually show that they're generating revenue, that they have a need for an employee. I see no reason why they wouldn't be able to file a petition on his behalf. Now, if it is a cap subject role, right, they'll have to wait till next year. But there may be other options for him, and I really don't know. I mean, I don't know what kind of business it is. I don't know what his background is. But assuming, all things being equal, that it's just the H-1B, right? Wait until next year, preserve whatever status you are in, and then if you're hoping for a change of status, number 1, determine whether or not you have to make a filing with the Department of State, right? Because you often have to do that if you're applying for permanent residence, changing from a diplomatic status, right?
You would.
So that's a process. It takes a bit. And often it'll take longer than most people expect. So the reason why, it has to go through all kinds of bureaucracy in order to get the approval, right? So
the way I see it is pretty straightforward. I mean, the only thing I can see is the problem. Like, I don't understand why you think it would take longer.
just experience.
Okay.
So assuming that you're hoping to start, let's say, October 1st, not of this year, but of next year, right? The timing would be that you're either applying for a change of status on that date, or maybe he leaves, you have the approval, and comes back after an application at the consulate in his home countries. I just want to mention something that I'm not sure was mentioned tonight. Even though a petition is adjudicated by the USCIS, when you apply for a visa with one of the U.S. consulates abroad, those folks have the right to look behind the approval. They can look at the petition, and they can deny your entry. So even though it seems automatic, it's actually a double check system. Just worthwhile mentioning.
Hi, good evening. Thank you so much for to be here, help us. I have 2 visas, press visa for 5 years and J1. And my question is for William Johnson, I think. You said that when you finish your J1, you must go to your country to be 2 years. But I have the press visa at the same time, so I could be in the country working again with my company. That's my question.
Right.
And the second, sorry.
Go ahead.
And the second question is if I can apply for O1, if it's possible, during my J1 here or not. That's my question. Thank you
Right.
so much.
So only certain J1 visa holders are subject to the 2-year home residency requirement. So it's fairly easy to find out if you are. Just take a look at your J1 visa, and there should be an annotation that says subject to 212E or subject to 2-year home residency requirement. If you are, then before you switch to HL or permanent residence, you would have to go home for 2 years. If you're not, and you meet all of the requirements for the EB11 category, then you certainly could apply. I mean, you'd have to really sit down and take a look at your CV with an attorney and figure out if you can make the case, because it's like my colleague said earlier, it's a very high burden for that type of green card case.
Can you have two visas at the same time, like she has?
You're not supposed to. You may have two visas in your passport, right? But you're only in one status.
Right now, yes, just with the J1.
Right. So what governs is what
Your last entry.
your last entry. So, or if you've changed status in the country since then. But in theory, you're not supposed to have two visas in your passport. Normally, when you apply for a visa, if you have an existing visa in your passport, they'll cancel that one if it's an employment-based visa.
Got it, thank you.
Here.
I would like to know if the communication field is in the O visa. Is considered in the artist category of an O visa. And I also would like to know if to apply for the A1 A visa, you have to have a job offer.
Sarah, do you want to take that?
Sure. So, the arts is a different standard, as William was saying. It's the lower standard. Whether or not your case would ultimately fall under that depends. So you have to carefully look at what your background is, what your position is, and whether you can make some claim that that's within the arts. I can't tell you, sure, communications is, or no, it's not. It doesn't sound like it is right out of the, initially, but it could be. It's really, really dependent on your situation. So you'd have to look at that carefully. And the second question I didn't hear.
It was about the A visa, the A1, and I was asking if it's necessary to have a job offer before applying for it.
The A1
What's
visa?
the A1 visa?
Oh, the A1,
Or-
sorry.
The H1B?
A1A?
L1A,
Yes.
the manager visa? Yeah, you need a U.S. company to sponsor you, so yes, you need a job offer.
So that would be an intercompany transfer, right? So she needs to be in that company for at least a year.
Right, the requirement is that in your case, it would be for one of the 3 years before you came to the U.S., assuming you're still in some role affiliated with that company. You worked for the company in a managerial or specialized knowledge capacity.
So I know when you apply to an H1B, sometimes even if you get in the lottery, there's times where when they check your application, you get rejected. And also in the case of the green card lottery, for example, I heard rumors that there's, they select more engineers and business people because that's what the U.S. needs. And I don't know, is it true or this, and what are actually the reasons why some applications are rejected?
Sarah.
I don't think it's true. It's a rumor. We really have no way to know whether behind closed doors immigration is doing something. Maybe, I don't know, but I don't believe that that's the case. And as far as I understand, it's literally a lottery. And if your case is selected, it gets adjudicated.
So it's for sure if you get the lottery, it's for sure you get the visa.
No, if your case is selected, then your case gets adjudicated. That means they look at your papers and they decide whether your case is approvable. If it's approvable, they approve it, and if it's not approvable, it could get denied. So you have the chance, basically.
2 more questions.
I'd like to ask, I have a couple of prospects that have a J1 visa, and it's going to be expired within this year. They're both from Spain, and I want to apply for them to continue working at the U.S. Before the the expiration of the visa. So what is the situation? Do they have to go back to Spain? Can they stay and can they process the visa in the U.S. or they do have to go back to Spain?
Yeah.
Well, I mean, there's a couple different considerations. Could they, in theory, file a change of status to E, assuming they qualify? Maybe, but you'd have to look at do you know what kind of J's they're on?
What kind of what?
What kind of J1s do they have?
I don't know. They're interns, regular J1s.
So I'm guessing when you filed that application, you also filed a statement saying you were not going to change status to or try to sponsor the person for future employment. So that would mean that the safest thing to do would be to have the person apply at the consulate for the visa, and especially since you want to sponsor them for an e-visa, because the way the e-visa works is that you can apply through USCIS, but when it gets to the embassy, normally it's sort of a pro forma process if the case has been approved by the Immigration Service. At the embassy, they look at all e-visa cases de novo. So you have to do the application process from scratch all over again. So it may make sense as a practical matter just to do it all in one shot at the embassy.
At the embassy in Spain, of course, right?
Yes.
All right. So they have to go back. Nevertheless, they have to go out of the country, and all the application through our company should be processed while they're in their country of origin. Is that?
Yes.
Yes. Thank you.
I have two questions. First of all is about the e-visa, the E2 visa. I think for Spanish companies it's probably a good option, right? Because they invest here, so that might be probably an easier option than the H-1B or some green cards, and of course. And my second question is that if you can have two J1s in a row, maybe if one of them is trainee and the next one is intern or vice versa.
Zach, you want to respond?
Thank you. So, yeah. So the E2, is it better or worse? You know, it really, they're not an either or, right? They're really meant as categories that would fit a particular situation. Sometimes you're lucky enough to have several situations that fit, right? You can get an H-1B, you can get an E2, whatever. So I would say that, sure, you know, if a company is looking to invest here, if they're looking to keep people here to direct investments, have managers, executives, folks here as a group, E is fine. What I don't like about the E, because I'm always looking to give people flexibility, right? You don't want to be tethered. So, you know, if you're an employer and I'm counseling the employer, sure, that's wonderful. You know, you have people who are going to be far more loyal, right? But if you're just an individual and you're looking at your options, think about what you want to do. You know, are you going to be in the same frame of mind 5 years from now? Because if you're in an H-1B position, and like I mentioned to somebody over there, you're granted employment authorization with a specific employer, typically in a specific occupation, right? Because you bring your credentials with you. Those credentials typically don't change, right? You're an architect, you're going to move from one firm to another, but you're going to remain an architect. It doesn't really give you the flexibility to start your own business, right? So it's a long way of saying that, yes, an E2 could be great for someone and may not be a good idea at all for someone else, because it's valid so long as the enterprise is functioning. After that, it just dies out, right? And then you have to think about what you're going to do next. So a lot of planning should go into it. With regard to the J's, yes, we can have a couple, but they have to be in different categories, right? Now, also keep in mind that the duration of these J's can be anywhere from 3 months to 18 months, right? And my view on the J's is that they are training with the benefit of hands-on employment, but really training, you know, and when it's internships, it's internship primarily, not a way to work here. And I think that's just kind of the policy that's coming back from the Department of State. They're cracking down. A lot of the program hosts are losing their licenses. So I would caution anyone, if they're looking for a way to employ people, don't think about the J. The J really should be about cultural enrichment, and it really exists as a way for the United States to provide something to folks. You know, during a set period of time, they go back to their home countries, or, you know, if during the time that you're here you get an offer of employment, fine, that's wonderful. But, you know, going into it with that intent is, from my standpoint, from what I'm seeing in the last several years, it's not advisable. I would really not do that.